All right, we're here back again on the Fournier matter. Mr. Gilo, how would you like to proceed?
Well, at this time, he does qualify for court-appointed counsel.
He does or does not? I'm sorry.
Pardon me?
He does or does not?
He does.
Okay, all right.
He's not working, so.
Right, okay.
That issue's over with now relative to bond. Would the court consider 50,000 10%?
All right, well, I'll hear Mr. Fenton's argument. Did you wish to make argument or just wait until he's concluded?
I'd like to make an argument against reducing his bond. First,
Right.
I had
Yeah,
if he wants to
give you
argue
that
first,
chance.
that's fine.
So, Mr. Gilo,
What?
Did you wish to make a bond argument? I mean, I'm interested in what happened, not obviously the events that got him arrested, but well, let me just hear what went on. Mr. Fenton, your position?
All right, well, I oppose any bond reduction and I was going to ask for an increase on the one, trying to figure out all my notes here because it's in two different files, but it's my understanding that he was on bond for a drunk driving third when he picked up this new drunk driving third. And normally that would revoke someone's bond. They shouldn't have bond at all. But in addition to that, it's my understanding that, let me get back to my previous file notes, that these are not in isolation, these OWI thirds. According to the charge notes on the older case, this is his 7th OWI third offense. And I think he's been ordered to test regularly. I think that was part of his original bond conditions. And that did not stop him from drinking and driving again. So I think bond should be revoked. He should be in jail, not anywhere else. He's an extreme danger to the public. Anybody that's been charged with and convicted of drunk driving as many times as he has, and then is currently facing felony drunk driving charges and picks up another felony drunk driving third, is a clear and obvious danger to the public.
All right, thank you, Mr. Gilo.
Well, the only missing tool there is that he doesn't have a record of not showing up in any particular hearing. The argument relative to alcohol intake can be taken care of simply by the court ordering a supervision device that he has to activate on a daily basis. So with that said and done, and he does not have a record, like I said, if I didn't say it, of non-appearance. So I can understand Mr. Fenton's, Mr. Fenton's argument that he may be a danger to the community, but there hasn't been any evidence presented that even when he was driving under the influence, that he committed any harm to the community. Not that that means much, but what it tells me is that he's not, if he does in his past, he drank, but he didn't drink to the excess that he was all over the road or hitting people or anything of that nature. So why can't we put the breathalyzer back in the vehicle, let him go to work, monitor him one more time, set a bond that he can reasonably afford, and go on from there. Thank you.
Did I not give him a breathalyzer requirement on the first of these two cases?
Daily PBTs.
Yes.
No, he has a device.
No, he had a device of some kind.
Because we got reports.
Yeah, Ms. Payne is indicating we got reports. And yet there's at least the allegation that he was drinking after that. Mr. Fournier, anything you wanted to say?
Your Honor, I have no problem conforming to doing whatever you guys need. I really have been on my boots to getting into rehab. I was supposed to make a bunch of phone calls again on Monday. I have a couple more lines on it. As it stands right now, if I keep my job, I still have insurance. I can actually afford to go to a rehab. I will be able to afford my counsel and my counseling. I really have worked my life off to get to where I am. I don't want to ruin it by alcohol, and I don't at all want it to define who I am. Obviously, I'm no good on it. Obviously, it doesn't need to be a part of my life. It's obvious that it's done nothing but harm to me. I would be willing to go up, talk to Mr. DeLeo and get a STRAM program put on my ankle. I would be willing to reinitiate, get that Smart Start box hooked back up and turned back on. I went to go make my payment and they shut the dang thing off. It was a problem after a problem after a problem. I want to do whatever it takes. And if it means you calling me on a daily basis or the jail calling me and saying, hey, come in and test, I will. I do not have a problem with that. I will make it top priority.
All right.
According to my
Well,
notes, that was already ordered.
I have no doubt that you would appear. What I'm looking at is allegations of in August of 2000, operating while intoxicated, January of 2005, operating while intoxicated, August of 2006, operating while intoxicated, October of 2007 or 2010, operating while intoxicated, June of 2013, operating while intoxicated, January of 2019, operating while intoxicated, and now 2 new pending charges, both of which allegedly occurred in 2023. And in one where I had a testing module set up, even if I set up the best testing system in the world, that doesn't keep you from consuming alcohol. That's my consideration. While I always have the right to review bond, I do think it's appropriate in these cases based on what I've heard, and particularly what I'm looking at this, I'm going to revoke the bonds in both matters. I don't think it is safe for you to be on the road at this point. I admire your desire to get into rehab. It's undoubtedly what you need, but I can't take the chance at this point that you won't be drinking. So bond is revoked in both these cases. All right.
Are we in any kind of position to make a decision as to prelims at this point or not?
I think at this point, especially since you just got an attorney on the new case, we'll be back here, Mr. Gilo, in 1 week or on this one, both cases rather, in 1 week.
That'll be fine.
All right.
And I'll be filing my appearance on next in rotation.
All right. Okay. Thank you. All right, Mr. Fenton, I know you'll be down here. We'll take a brief recess, and when you're here and ready to go, we'll get started.
Thank you, Judge.
On the record in the matter of the state of Michigan versus Javion Cunningham, 2-3-1-6-8-4. And your name again for the record.
Detective Sergeant Ken Brooks.
All right, you're still under oath and you may proceed on the warrant.
On Saturday, June 24, 2023, approximately 19:15 hours, WANNABE officers Judge Detective Haskin were driving a semi-marked police car 7-6, and Deputy Chief Hamilton and myself were driving a semi-marked WANNABE police car 718, and we were working the 4th Street Dream Cruise. Officers were driving back from a previous call and were in the area of Fort and Southfield in the city of Lincoln Park when we saw a male later identified as Cunningham driving a white and blue dirt bike southbound on 4th Street. Mr. Cunningham was driving in a reckless manner, doing wheelies, standing on the seat, and continually driving excessive speed, and he was not wearing a helmet. He just had sunglasses on. As the dirt bike reached southbound 4th Street crossing Goddard, officers saw that the bike did not have a license plate and attempted to stop the bike with emergency lights activated. The driver, later identified as Mr. Cunningham, pulled to the right, cutting off several southbound vehicles and entered the bar parking lot. All officers activated activated their emergency lights and siren in an attempt to stop Cunningham. Cunningham sped through the lot and onto northbound Drury Arc towards Goddard. Officers got stuck in traffic and weren't able to, when we got to Goddard, we lost sight of him for a few seconds. As officers approached 4th Street, officers saw that Cunningham was now northbound on Fort from Balmy. As Officer Judge and Haskins approached the intersection, Cunningham turned the bike directly at the officers, nearly striking the front of their vehicle, and then fled westbound on Goddard. As the Deputy Chief Hamilton and I got to the intersection, we attempted to stop Cunningham, but he was able to drive around our vehicle and flee westbound on Goddard. As Cunningham passed our police vehicle, DC Hamilton saw the end of a handgun sticking out on the right side of Cunningham's pants and waistband. Cunningham reached speeds over 75 miles an hour in 25-mile-an-hour zone, failing to stop for all traffic control devices while driving westbound on Goddard. Cunningham turned northbound on Dix, then made a U-turn, went back southbound on Dix, doing a wheelie through the intersection of Dix and Goddard's, heading southbound, reaching speeds over 75 miles an hour. At Dix and Wesley, Cunningham drove onto the sidewalk, turned around, and drove right back towards officers, nearly striking in front of our police cars, then fled northbound on Dix at a high rate of speed. Cunningham reached speeds over 70 miles an hour or 75 miles an hour in a 40-mile-an-hour zone, disregarding all traffic control devices. Once Cunningham entered northbound 75, the chase was terminated. The Wyandotte Police Department took images from the in-car camera of the driver on the dirt bike and placed them on the department Facebook page, asking for assistance to identify him. The department received numerous tips that the driver of the dirt bike is Mr. Cunningham. Detroit police officer Stephen Kosa called and stated that he went to high school with Cunningham and he was positive him that was driving the dirt bike. Officer Kosa provided us with Cunningham's Facebook page and a picture of Cunningham and his girlfriend, later identified as Kayla Holder. In the picture, several pictures on the Facebook showed Mr. Cunningham with a gun. We took several screenshots from Mr. Cunningham's Facebook page. We identified the lower, he has a lower left sleeve tattoo that we observed during the chase. Also the same, appeared to be the same type of chain. Within about 30 minutes of us on his Facebook page, the Facebook page was terminated. On Tuesday, June 27th, we conducted surveillance at 14 Apple Grove in the city of Ecorse. We did see a car that belonged to Mr. Cunningham, registered to Mr. Cunningham, parked outside the house. As officers were approaching the house, Ms. Holder exited the house, saw officers, ran back in the house, refused to come out for approximately 10 minutes. She came out, refused to let us access to the house. Mr. Cunningham refused to come out, and at that time we left. And I was contacted by an attorney who said Mr. Cunningham would turn himself into us, but he has yet to show up.
All right, thank you. Upon examination of opinion witness, I find the offenses charged were committed, that there's probable cause to believe the defendant committed the offense. Would you like this returned?
Yes, please.
All right, the court's going to also indicate that that will be a $35,000 10% bond.
Thank you.
All right, thank you. Okay, and so, Mr. West, good morning, good afternoon.
Good afternoon, Your Honor.
Okay, and then is this your client, Ms. Stanley? Is that who's here? I'm sorry, please unmute, ma'am.
Can you hear me now?
Yes.
Yes, your name, please. Your name, ma'am?
Kimberly Stanley.
Okay. Well, Council, this might be a little bit unusual, but your client will be present because
Yes,
he's
Your Honor.
in the Wyandotte jail. He's in the Wyandotte jail,
Oh.
so he will be available on Zoom, and then I can we can proceed from there.
Okay.
It's kind of a first for me for my lieutenant matter, having a tenant in our jail, but in any event, we'll handle that accordingly. Okay.
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 Okay, but I have a couple other matters to handle, so I'm just gonna have you both on mute for a few moments.
All right.
Okay, so Mr. Serrano, are you ready to proceed?
Ready on all matters, Your Honor, yes.
Okay, and this is Mr. Zeppel, correct?
That's correct.
Okay, we are going on the record in the matter of the state of Michigan versus Thomas Michael Zeppel, 231698. And appearance, counsel?
Your Honor, good afternoon. Richard T. Serrano, P33828. I appear as MIDC counsel for arraignment purposes only on behalf with my client who appears in custody via Zoom. We have no objection. And please state your name, sir. Oh, Your Honor, we require formal reading on all charges, please. Please state your name,
Okay,
sir.
Mr.
Thomas Michael Zeppel.
Okay, the complaint alleges on July 6th of this year in the city of Wyandotte, it alleges that this is 3-count complaint, sir. Count 1, controlled substance delivery manufacturer of methamphetamine. It's alleged on the date I just indicated in the city of Wyandotte that you did deliver and or possess with intent to deliver the controlled substance methamphetamine contrary to MCL 333.74012 BI. This is a felony charge. Maximum penalty upon conviction is not more than 20 years in state prison and or a $25,000 fine. Count 2, controlled substance possession of methamphetamine or ecstasy. The complaint alleges on the same date and location that you did knowingly or intentionally possess methamphetamine contrary to MCL 333.74032 BI. This is a felony charge. Maximum penalty upon conviction is not more than 10 years in state prison and or a $15,000 fine. Count 3, controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams. The complaint alleged on the same date and location that you did knowingly or intentionally possess less than 25 grams of a mixture containing a controlled substance cocaine, contrary to MCL 333.74032 AB. It's a felony charge. Maximum penalty upon conviction is not more than 4 years in state prison and or a $25,000 fine. Habitual offender third offense notice. Take notice the defendant was twice previously convicted by felony or an attempt to commit a felony that on or about December 7, 2015, he is convicted of the offense of operating a lab involving meth in violation of MCL 333.7401C2F in the Third Circuit Court, Wayne County. And that on or about August 24, 2017, he was convicted of the offense of operating a lab involving meth in violation of MCL 7401C2F in the Third Circuit Court. Therefore, defendant subject to the penalties provided by MCL 769.11. That penalty would be twice the maximum sentence on a primary offense or lesser term. Maximum penalty cannot be less than the maximum term for a first conviction. Do you understand what you're charged with, sir?
Yes, ma'am. Yes.
All right. Sir, you have the right to have an attorney. If you cannot afford an attorney, the court will appoint one to represent you. In fact, you've had an opportunity to speak to an attorney today, correct?
Yes.
The court assigned the order for court-appointed attorney for felony purposes. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes.
The court's going to enter plea of not guilty on your behalf. Schedule this matter for a probable cause conference on July 14th at 9 a.m. at the 28th District Court.
Excuse me.
I'm sorry?
Could I say, I have a job, I work out of Riverview and I use my boss's truck to come home. so that I could go back to work. No drugs were ever in that or ever.
Hold on, sir. Hold on. Stop just a moment. Your attorney's going to address that.
Okay, well,
And so, counsel,
took his truck.
sir, stop talking for a few moments. You have an attorney that's going to do some speaking for you.
Okay, thank you.
It'll be just a little bit before you can tell me what you want to tell me.
Okay.
Okay. And so, counsel, as to bond.
Your Honor, my client does affirm that he has one case pending in Wayne County on a felony matter. Nature of the same charges as these. He's told me that he has private counsel for that case, but he's maybe seeking court-appointed counsel for this case. So he started to tell you he is working. Your Honor, he's a resident of the area. He's single, he sports no children. He says he's never missed a court date before. That's about all I can say in his favor, Your Honor, because the court well knows that he's had cases like this before, some criminal history. So we ask the court to use its discretion. If not a personal bond, that a bond you can reasonably expect to post, I'm sure the court will impose some conditions as well. Thank you.
I have a GPS tether right now.
He does have a tether, yes.
Which doesn't seem to be doing much good at this point, but in any event, Detective Sergeant Grote, your name for the record, please.
Your Honor, Detective Sergeant Ken Grote. Your Honor, Mr. Zempel is currently on a tether for Wayne County. It is our understanding, speaking to the Trenton Police Department that's in charge of the investigation, that Mr. Zempel took a plea deal and was to be sentenced to 4 to 20 years in prison starting June 30th, but that was moved to 2 weeks into July. He was going to be sentenced, so it appears he's going to be sent to prison. We're afraid he's going to flee the state. We hear he's getting evicted out of his apartment. Obviously he hasn't learned his lesson. He has a long criminal history of making meth and selling meth and using meth. We feel that he's a dangerous to society. We'll ask for $1 million cash.
Okay, so I just have a couple of questions. So the case that Mr. Zempel is being sentenced to 4 to 20 years in state prison. It appears as though, so all of those cases are out of Trenton?
Yes, ma'am.
And so am I looking at this correctly, where one of these cases originated December 18th of 2021, another one August 30th of 2022, and then another one September 25th of 2022?
Yes, ma'am.
And so then these were all combined together?
I believe there's one, I believe they were all combined together. That's how we came up with the deal. One is a over 50 case also.
And then there's another one from March 5th of this year. Is that included in that resolution?
I'm not sure.
Mr. Zempel, is that one also included in that resolution?
I'm not sure which one. Was it the one where there were, they found crumbs? There was like, they're charging me with possession, but there wasn't even enough to test. I think it was pretzel salt they were claiming was meth. I don't know. They tasted it and it tasted like meth, I guess. I don't know. I'm not even sure.
I don't know, sir. Sir, listen. You have multiple cases from the same jurisdiction. And so clearly you can't keep those straight either. But what that tells me is that you've been out on bond on all of those matters and still violating bond, but yet you're still out on bond and not in custody.
Okay. I'm a drug addict.
And now, oh sir, it seems to be you're more than a drug addict according to what you've pled guilty to and your previous convictions.
It was either that or I could get a lot more time.
What?
It was either plead to the 4 to 20 or I could get a 10 to life. So I took the 4 to 20 versus the 10 to life.
Well, in 2019, you pled guilty to habitual offender 4th offense. So perhaps the Wayne County Prosecutor's Office missed that when they charge you as the third offense, as opposed to the fourth offense. However,
Either way, I'm gonna die in prison.
well, either way, sir, prison has not
Haven't did shit.
helped
I'm
you
a drug addict.
not
I need
reoffend.
rehab. I need rehab. I don't need prison. I need a rehab. And they never give me rehab.
Sir, I think at this point, given the charges that you've been operating a meth lab, you have 2 of those convictions, and that your convictions that you just pled guilty on were possession, delivery, manufacture.
Which was wrong.
Delivery, manufacture, delivery, manufacture, possession, I think you're pretty well beyond the rehab at this point. But in any event, the court will note that given your criminal history, the plea deal that you just took, that's the same type of case that you are charged with now. You're scheduled for sentencing in a couple of weeks to be sentenced to 4 to 20 years in prison. And while you're awaiting sentencing on that, it's alleged that you've committed the exact same type of offense. Not to mention, your criminal history would suggest that while you're out on bond, you're still violating the law multiple times over with the same offense that you are out on bond for. So for those purposes, the court's going to remand you without bond. And so you can be sentenced while you're in custody.
Do you think you could give my boss the truck back since it was never used for anything to do with drugs?
Was the vehicle forfeited?
Yes, ma'am.
Okay, well then your boss is going to have to go through the process, sir.
We spoke. That's bullshit. It was parked on the street. I only used it to drive home.
I'm sorry, what is it you just said, sir?
I said I only used the truck to drive home, and that's it.
No,
I didn't have no drugs in it.
Before that.
I don't know.
Okay, well, as the court indicated, you're being remanded without bond based upon your criminal history, the fact that you're awaiting sentencing on the same type of charges that you have, I believe, 4 or 5 different cases that arose from the same jurisdiction, the 33rd District Court. For some reason, the 3rd Circuit Court did not find it necessary to remand you while you're awaiting sentencing. And then here you are yet again. You have 2 previous convictions as well for operating a meth lab. So for those reasons, the court's remanding you without bond.
Thank you, Your Honor.
Thank you. And the detectives are in touch with your boss, sir. All right, thank you. We're going to be off the record.
I won't be talking to my boss.
Yeah.
All right. All right, while we're waiting for him, I think we're going to go ahead with his Webster's case. And ma'am, are you Samantha Webster?
Yes, sir.
All right. Mr. Gilo, how would you like to proceed?
Just an arraignment?
Well, she was arraigned and then a bench warrant was issued. This is it's a 23 case. She was arraigned on May 11th. Bench warrant was issued on June 8th. It's a methamphetamine case. Mr. Gilo, have you had a chance to talk to her?
Yes, I have talked to her, Judge. Relative to the bench, we're here on the arraignment. Is that it?
Well, it's a bench warrant arraignment. She's already been arraigned, so I'd really treat this as a felony status review on the methamphetamine second offense case.
Okay. I wasn't aware of that.
All right, then this is probably just a bond hearing at this point. Let me hear from Mr. Fenton first, and then I'll get back to you. Mr. Fenton, as to bond.
Well, if this is an arraignment on a bench warrant, I'd like to hear the reason. First, I'd like to know what the bond is right now. Has it been changed since the original bond? I presume it has. What excuse she may have or not have for not showing up. And I'd like a minute to please look at the original bond request as well.
It was a $5,000 personal recognizance bond. She, I believe, was just recently arrested, and so bond has not been reset.
Okay, thank you. I can just have a moment to look at my original request. Original request was for 5,000 cash or surety. You indicate the original was PR?
Correct.
Okay, so I renew my request for at least a 5,000 cash surety pending any sort of explanation as to why she failed to appear.
All right, Mr. Gilo, any comments on that?
Oh, yes, I talked to my client about that. First of all, she doesn't have transportation. She lives out of town. Number two, she didn't have a phone. She couldn't afford it. And so, being that said, she did not at least leave town or anything of that nature. So I'd ask the court to consider a 10% bond, $5,000 10% bond. She does have a place to live. She's living with her mother.
She didn't have to appear personally, Judge, and everybody knows someone with a phone. She knows her obligations. I really think a cash surety bond at this point for 2 failures to appear and the seriousness of the charges is appropriate.
All right, Ms. Webster, anything you wanted to say concerning bond?
Yes, there is, sir. I don't have anybody with a phone when I live 6 miles out of town. There's nobody's going to bring me a phone that far out, and there's no way I can get a hold of them. I can't have anybody come to my house. My mom has stage 4 cancer, and she still is dying. Like, there's no excuse why I didn't go to court. I understand that. Like, it was stupid of me not to go. Like I said, they had asked for another PR bond, like, if possible. I don't have the money to get out. My mom, I'm still taking care of my mother. Like, I'm not trying to screw anybody. I haven't left my own house. Like, I've been at the same house this whole time. Like, I just apologize for missing court, and it won't happen again. I do have a phone now. And yes, that's all I have to say, sir. Thank you.
But did you make any efforts to contact your attorney or the court in?
Sure, when I'm at my mom's house, I've been stranded out there. I literally just got a phone the day before yesterday. I just got one. Like, I just started working at the Green Lantern during waitressing during the daytime for lunch business and they really my mom takes up my whole time.
I do remember your statements concerning your mom, and that's why, certainly contrary to what the prosecutor wanted, why I made it a $5,000 personal recognizance.
Yes, sir, I remember that.
$5,000 cash or surety, but now we're back here and it's the same situation, and all I'm being given is the same promises. I can understand it's a difficult situation. On the other hand, it was a difficult situation.
Just ask for one more chance, please.
Well, I will set a $2,000 cash or surety bond. I will reserve the right to address bond again if I think it appropriate. I think $2,000 is appropriate, probably low in this regard. We will set it for a felony status review. We'll be back here on the 13th, a week from today. All right. Thank you. That does conclude this matter. Ronald Fournier.
Very good.
Okay, he's in jail. Right, all right. And in the meantime,
Larry Brown on Mr. North relative to what he wanted to do. If you wanted to call that case, we could I could indicate what Larry Brown has told me to ask for.
Mr. Trush was also standing
I
in.
think Mr. Brown may also be with us.
And is Mr. Brown with us? He is.
I actually am, Your Honor. I just got out of circuit court.
All right. Well, welcome. So I feel like I'm being triple teamed. That's great. Okay, this is Mr. North. We'll call his case. And Mr. Brown, how would you like to proceed?
If I could have one moment to pull my notes up here. Your Honor, at this time, I did speak with Mr. North yesterday. He advised me of some things that have given me some pause that I might want to request a forensic evaluation. However, there's also an issue that I'm waiting on some lab reports. He apparently had some blood drawn. I don't have those lab results yet. So I am going to ask for an adjournment.
All right. And as to the 21-day rule?
Your Honor, it was difficult speaking with Mr. North. I would waive that, but I do need to verify that with him.
All right. I will. Do you have any objections if I inquire?
I do not.
All right. Mr. North, did you hear what your attorney said?
Yeah. I just have a question. Why did you raise my bond last time? When I was mentally ill, why did you raise my bond?
Well, Mr. North, you don't want to talk right now, okay?
I wanted to know why the judge raised my bond and doubled it.
This is the first time I've handled this case, but let me explain that you had the right to a preliminary examination within 21 days. Your attorney has recommended that you still keep your right to a preliminary examination, but that you do not have it within the 21 days so we can get further information. Is that agreeable with you?
That's fine, Your Honor. Where is the scumbag that chased me around in the gas station with the gun?
Okay, we're done.
Where is the accuser that accused me of taking his car after he had a gun chasing me around the gas station?
Enough. Enough.
How about giving me a personal bond?
Could we mute that? I don't want him to say anything.
I think it is being in the process of being muted. We'll be back here in about 3 weeks, Mr. Brown. I will accept the 21-day rule waiver. And
don't give me a personal bond, huh? That's fine.
No.
You're going to wish you did.